The Supreme Court on December 11 said the abrogation of Article 370 stands valid, and let me decode the Supreme Court's verdict and the legal turning points of the case in simple terms. But first, how did Jammu and Kashmir get special status and what followed? In 1947, following partition, Jammu and Kashmir, a princely state with a Muslim majority and a Hindu ruler, witnessed high tensions with both India and Pakistan coveting it. The ruler of the state of Jammu and Kashmir at the time, Maharaja Hari Singh, decided he did not want to join the newly democratic India, nor was he inclined to side with the Muslim majoritarian Pakistan. He wanted Kashmir to remain an independent state. On October 24, 1947, Hari Singh appealed to India for military protection against threats and attacks from Pakistan. In return, he would cede Jammu and Kashmir to India. The result was the signing of the Instrument of Accession, where India would not be given complete control over the state, but the Indian Parliament could enact laws on three subject matters: defense, external affairs and communications. Everything else was left to the state of Jammu and Kashmir. Further, the state was not bound by the Constitution of India, which was being drafted at the time. So, Article 370 was introduced, and this article was titled Temporary Provisions Concerning the State of Jammu and Kashmir. The purpose was to enable Jammu and Kashmir to transition from an independent princely state to a democratic state of India. Essentially, Article 370 did three things. One, it limited Parliament's power to make laws for Jammu and Kashmir to the three subjects I mentioned earlier. Two, it stated that the Constitution of India did not apply to Jammu and Kashmir except Article 1, which states India is a union of states. And three, this is the important thing, it stated that this article can be amended only by the President with the consent of the Constituent Assembly of Jammu and Kashmir. Here is the catch though. Once the state's constitution was drafted, the Constituent Assembly ceased to exist in 1957. The power to modify Article 370 was in the hands of the Constituent Assembly. The difference between a Constituent Assembly and a Legislative Assembly is that a Constituent Assembly's main function is to draft or amend the Constitution, while the main function of a Legislative Assembly is to make laws. With the Constituent Assembly of Jammu and Kashmir ceasing to exist in 1957, those against abrogation argued that the President could no longer modify or repeal Article 370. So, to overcome this catch, what the BJP-led union government did in 2019 was to amend Article 370 by first amending Article 367 and stating that the Constituent Assembly of the state referred to in Clause 2 of Article 370 shall read Legislative Assembly of the state. These amendments established a circuitous route to abrogate Article 370. Earlier, modification to Article 370 was not possible because the powers for it were in the hands of the Constituent Assembly. An amended Article 367 gave the centre the chance to exercise the third clause of Article 370, which states the President may, by public notification, declare that this article shall cease to be operative or shall be operative only with such exceptions and modifications and from such date as he may specify, provided that the recommendation of the Constituent Assembly of the state referred to in Clause 2 shall be necessarily before the President issues such a notification. Note the use of the word Constituent Assembly. This is why Centre modified Article 367 and interpreted Constituent Assembly as Legislative Assembly, because at the time the Centre abrogated Article 370, Jammu and Kashmir was under President's rule, and the Legislative Assembly in this case was the Parliament. In this regard, the Supreme Court has said that the abrogation of Article 370 stands valid because Article 370 should have ceased to exist in the first place after the dissolution of the Constituent Assembly in 1957. The Supreme Court order says that the abrogation of Article 370 was a culmination of the integration process of Jammu and Kashmir with the Indian Union, and Article 370 was a temporary provision anyway. The court did not agree with the Union government's amendments to Article 367 though. Now let's get to what the Supreme Court has said with regards to the centre's actions. The petition against the abrogation of Article 370 argued that the government's intention behind the move was not right. It challenged the constitutionality of the presidential orders CO 272 and also the bifurcation of the state of Jammu and Kashmir into two union territories, Jammu and Kashmir and Ladakh CO 273. In response to which, the court has basically said the Election Commission must ensure that elections to the Jammu and Kashmir Assembly must be held by September 30, 2024 and that the Union Territory must be granted statehood at the earliest. However, since no specific time frame has been laid out by the Supreme Court for restoration, this aspect of the judgment is likely to remain a contentious issue. Article 367 is an interpretative clause as opposed to the centre's claim of it being a substantive clause. Third, the method adopted by the centre to amend Article 370 was invalid, but the intent behind the modification was not mala fide, which means there was no ill intention behind Constitutional Order 272. Essentially, the court ruled that the circuitous route taken by the centre to abrogate Article 370 was unconstitutional, but the final outcome, which is the abrogation itself, was not. Apart from this, the Supreme Court upheld carving out Ladakh as a union territory. The court, however, refused to adjudicate on the key question of whether the government had the power to downgrade an existing state into a union territory. How will this verdict impact Jammu and Kashmir and Ladakh? Will elections be held next year for Jammu and Kashmir? It's wait and watch.
Subscribe to the Federal's YouTube page for more news and updates.